Today is March 11th, 2024, and this week I am pulling up the Form 22L and Form 69. And these are two forms that are used to do what they call a lease review. And what that is when a tenant is occupying a property that's being sold and there's a contract in place, it is a review option to look over what exactly that agreement is. And a buyer will know then going into the sale what they have to do to keep up this agreement, how long this agreement is good till, and they'll have a pretty eye-opening picture of what that contract looks like with the renter. I also wanted to talk about the fact that this is, we're going to be discussing rentals and leases, and just to let everybody know what our limitations are as licensed real estate agents versus property management. So the purpose of the form is to be paired with residential sales that have a tenant that's occupying the listing. That tenant, the form should be used when the tenant has what they call a term lease. And I'll go over exactly what that means as well. This form is for the ability to review the lease files and the accounts, to understand the lease agreement that's currently in place, to allow a buyer to review that lease, and to allow a buyer a contingency to review this. So it does give them a contingency out if they don't like the way this is set forth. So there's two different types of tenancy. And I'm not getting super into this because we are not property management, but we do need to be aware of what these are and what they mean. So the first one is called a term lease. And in a term lease, there's a contract in place for a specific amount of time. Typically, this is done for about a year, and it's renewed or renewable annually. A month to month is when there is no contract in place, or perhaps the term lease has expired and no new lease has been put in its place. This is an implied month to month. And the result of this is the tenant just pays monthly until somebody ends that sort of tenancy relationship. As a reminder, as we talk through about this form and about rentals and leases, we as agents cannot manage money for accounts for rental agreements. We're just not licensed as real estate brokers to do so. There's trust accounts and financials, and those are kept up. They should be done through the property management, and we do have a property management division. As you remember, it's TMG Property Management. So just some things to keep in mind when we talk about landlords and tenants. Number one, a seller or a homeowner has the right to sell their house without limitation. So even though it's being rented by somebody living there, that homeowner does have the right to sell the property. Now, the seller may change property management companies freely without the consent of the tenant.
Makes me wonder if Carrie realizes half her hair is.
Hang on, Tony, I'm going to mute you. Sorry. There you go. So the seller may change property management companies freely without the consent of the tenant. If a property management company changes are made, then the seller may not make changes that impair their tenant's contractual rights to their lease. So basically, any changes that are made are done behind the scenes without any effect to that tenant or the contract they have in place. And this is why it's important for us to let our clients review this if they're taking over the sale. Number four, if a tenant is in the home, then the tenant has the right to live there until the end of their lease, regardless of the closing date. So if somebody's living in there and they are month to month, they have the right to live there until notice is given and that proper amount of time allows them to move out. And if they are on a term lease that expires 6+ months down the road, then they cannot be kicked out at closing because the home is sold to someone else. A seller may serve a notice to vacate with no term lease, but it has to be given so as required by the county. So right now, our state law says that they require 90-day notices for you to vacate one of the tenants. Be really, really vigilant on this and checking with the county, though, because King County has their own rules, Snohomish County has their own rules, but as a state, our general time frame is 90 days. And then, of course, last, a seller must adhere to the Landlord-Tenant Act when they're handling any money. This includes payments, deposits, and they need to adhere to the Landlord-Tenant Act when they're delivering notices and disclosures. So new buyers coming in are going to have to make sure that the tenant has all the disclosures required by law, as they will be the new landlord. The form we're going to look at to go over all of these things is Form 22L. It is called the Lease Review Addendum. So I just wanted to pull it up here so everybody could familiarize yourself with what it looks like. It's a really short form, but it allows a lot of contingencies for the buyer to look over everything that's in place. So the first thing you'll want to acknowledge right here is that this form is for when a tenant is occupying the property and there is a rental agreement that is going to remain in effect after the closing date. This is not, my brother or my cousin is living with us and they're going to move out at closing. This is for a rental agreement with a true landlord-tenant relationship where it extends beyond closing, and at the closing date, you will have somebody occupying that property. The agreement that will remain in effect after closing will either be a month-to-month, where the tenant has to be notified to vacate, or a term lease that remains until the effective date. This number 2 is a document delivery date. So just like some of our other contingencies, the seller has until so many days to provide all documentation and paperwork regarding this agreement. This includes, any property management agreement, any service agreement that they have, any agreement with other professionals, any leases that are in place. And this includes leases of the fixtures and the property, anything that tenant is making payments on. It include a schedule of all the rent deposits, the maintenance records, and all of the accounting. The seller has to provide these documents to the buyer. The default date is 10 days for all these documents to be provided. And this is going to be treated as any other contingency when it comes to document delivery notices. So think of it like you would the HOA review, or maybe the well documents or septic documents, where you have so many days to receive those documents. Once received, that is when the timeline starts for the review of those documents. So the default time to review is 5 days. And in those 5 days, it obviously starts at the date of delivery or by the expiration of that previous paragraph. Now, keep in mind, if you are never given documents and they never get delivered, then the contingency for that buyer of yours to back out of this contract because they didn't receive anything does start at the 10th day when they did not receive what they should have. If you do not disapprove of this, it will automatically waive and you'll move forward to close. So this timing is very important. Make sure that your buyer has everything they need to make an informed decision when it comes to reviewing anything that's going to potentially prohibit how they use the property after closing. This could also be affected if there's a specific type of financing in place that does not allow rentals to be done after closing. So if there is a tenant in place, this form is really just a fail-safe. Now, when it comes to transfer of leases and interest, buyers, you are responsible for ensuring the transfer of the lease paperwork, that you're responsible to make it sure it's set into motion. Escrow will prorate similarly to utilities or HOA fees. So this form is basically the instruction to do that proration and then the payment of any back owed fees from the tenant to the seller. Think of it similar to the 22K. And then sellers be on notice basically that at closing, at the close of the sale, sellers are no longer entitled to any of the rent monies at all. And it is the seller's responsibility, the seller's responsibility to the property management company ends. So what happens if you don't like what you see? Like I said, if you do nothing, it moves you towards closing. If you want to actually reject this, there is a form called the Form 90LR. This is the lease review notice, and it is just a termination notice. If there's something that you find in this, on the paperwork, the financials, the rental agreement, it could be anything that you find. If it is not, if your client disapproves of it, you do need to give notice with the 90 LR. So how do we transfer these accounts? I said earlier that a property management company can be transferred and it does not need the permission of the tenant. How do we do this sort of transfer? Well, the Form 69 is an assignment of the lease or rental agreement. So just as we may assign a contract to a different buyer, we can also assign the lease agreement to the incoming purchaser. The Form 69, the Northwest MLS requires that the lease be transferred to the new owner, which is the buyer, if the lease agreement remains in effect beyond the closing date. So the seller assigns their rights, title, and interest in the rental agreement to the buyer. And by signing this Form 69, the buyer agrees to assume the lease or rental agreement that's in place. This means that you also need to have had the chance to review this. So when your buyer signs it, they know what they're signing. The buyer must perform all of the obligations that were agreed. So read carefully what the buyer will be required to do. So any of the agreements that were in place for that rental agreement with that tenant have to be honored. The buyer obligations to the lease and rental agreement start at the closing date. So just like utilities, it is prorated and it starts at the closing. And the utilities can be transferred to the renter's name as soon as they take possession. So if your client is worried about, if you have a seller client who's worried about electricity being in their name and maybe the renter not paying it, electricity is one of those things that follows the person, not the property. So you can go ahead and transfer utilities to the renter's name. Now, when it comes to assigning it, I said it was Form 69, and I'm just bullet pointing really quickly how to fill it out. The top is going to be referencing the purchase and sale agreement date. And when it says assigner and assignee, the assigner is the seller and the assignee is the buyer. The property address that goes here is the property that's being sold with the rental agreement in place. Now, the purchase and sale agreement, the first line, we're going to note the purchase and sale agreement date. And then it says the assigner agrees to assign its right, title, and interest in a lease or rental agreement for the property dated blank. So you'll want to reference the lease or rental agreement date between the assigner and the buyer's name. The assignee, which is the seller, or sorry, which I have to write buyer, seller, otherwise I just get way too confused. The assignee agrees to assume the lease and timely perform and discharge all obligations of the assigner. The assignee is the buyer. They agree to take over the lease and relieve the seller of all of their previous obligations. And then on the same form, it just has some of these clauses that we would want to put in here, protective clauses for a lease assumption. We're going to just bullet point that it is, we're going to specify when it gets transferred. We're going to specify that everything gets transferred and that the responsibility is taken off of that seller and put onto the new buyer. And all of this is drafted language for the lease transfer. We should never be drafting this type of language on our own. And because this form is available in our statewide forms library, we should be able to use this to fully transfer or assign this lease or rental agreement with the protections of lawyer's wording. So when do you need property management and when do you not? Well, property management is going to be required when you have to do maintenance and repair, property inspections. If there's invoicing that comes in, collecting money, expensing payments, doing any maintenance whatsoever to the property, renewing the leases. We just basically kind of stay hands off as real estate agents when it comes to anything financial. And because we are not insured to do any sort of upkeep with a rental, the property management, TMG Property Management, is going to be there to take care of all of those other parts. I just took this page from the TMG Property Management website, and this is just a list of the services they provide above and beyond going ahead and doing the rental contracts. And then if you need information on the TMG Property Management, because like I said, at the close, a new buyer can change the property management company without needing permission from the tenant. Here's the information of our property management. Also keep in mind, if you use TMG Property Management, they will keep you informed on the status of this rental. And if in the future it should become necessary for that new homeowner to sell, they will contact you first. Do not do the following. Make sure you do not accept or collect any security deposits without doing a move-in or move-out addendum. If you, this is for your client, you will not personally be doing this, but if your client wants to collect a security deposit, you need to be able to prove the condition of the home before it was moved in and the condition when it was moved out. We do have a move-in, move-out addendum. It is roughly 9 pages long, and it is an intensive checklist of the condition of the property. So if you have a landlord who wants to collect a security deposit, you will probably need to advise them that they have to fill out a move-in, move-out addendum and just double check the quality of that, of all the items on the list. Do not give any advice on who is or is not responsible for any repairs. Do not advise landlords on appropriate timing to give notice to vacate, because all counties vary. There is a statewide law that there is 90 days required, but King County, like I said, has, changed their rules over time, and it's really imperative that you just check on that and turn them over to somebody who is incredibly knowledgeable on the most current laws when it comes to that. Do not explain the eviction laws to your client. Do not maintain the property in any way. Do not advise anyone if a tenant stops paying rent. And do not collect any rent payments unless they are going through property management. Here's what you can do. You can advise your buyer client entering into a sale with a tenant to speak to property management. You can let your buyer know that a term lease will extend beyond the closing until the end of that term. We do want them to be prepared when they get into a sale that has a renter. So we want to be able to advise them how to move forward. You can provide your buyer with all the forms to allow them to review the lease that they will be inheriting. You do want to advise potential sellers who have term leases in place that the leases need to be still need to be honored. You can recommend that any month-to-month tenancy either be terminated or advise an incoming buyer of the risk. And you can let your buyer client know that they are free to transfer property management companies to TMG Property Management. Understanding the tenant rights is a key to our job. Even though we will not be doing property management personally, we need to be able to understand the basic rights tenants have and how to transfer real estate ownership in the event a seller wants to sell with a rental contract in place.